Hi, Kaylin. Welcome. Thank you for coming on today.
Hi, Jason. How are you?
Thank you so much for coming on. And I know you have so many great stories in terms of the amount of experience that you have with people doing somewhat unethical things. But there's recently, we talked about a case in 2019 regarding something about FHA loans. Can you tell us a little bit about that case?
Matter of saved off. I guess he didn't quite save himself, but that's his name. This is a 2019 disciplinary matter where the attorney who's currently serving time was internally suspended. He will have to he will file an order to show cause when he's released. And at that time, the disciplinary matter will continue. He'll either be suspended or disbarred, likely. But in that matter, it was a settlement attorney, real estate attorney dealing with funding sources for 8 real estate transactions. And in that application, he aided his client in obtaining fraudulent mortgages for unqualified buyers from the FHA. And that led to his criminal conviction and is also what led to his interim suspension with the courts, and he will be disciplined for it.
So, Kaylin, let's back that up a little bit. What if, so they obviously in this situation was a little unique because he was part of the fraud. So what happens when it's not as clear if the attorney knew that the mortgage was fraudulent? What happens in that situation?
You see, it all depends because based on the case, what I know so far, it's not like if the attorney turns a blind eye to what is happening,
Right.
it will still result in that attorney being disciplined. So you may not, initiate it or be an active participant, but if you're signing those documents and you're reviewing them, it's just like when you file a complaint in federal or state court, right? You can be sanctioned for that because now you've signed on and you're signing that those complaints are not meritless or frivolous. It's similar to when you are guiding your clients in these matters, right? Even if you are not intentionally going out there and being an active participant, if you have turned a blind eye, it may result in you aiding and abetting your clients and then you being disciplined for such action. Because in this, there's no evidence that there are some cases where the attorneys, they're a part of the scheme, they're very active. And in others, they have turned a blind eye or know that the document that they're filing is not what it purported to be.
I see. Now, Kaylin, obviously we have always young attorneys, new attorneys that get into this world of practicing, and they're not as experienced as you are. What tips do you have for them to kind of protect themselves in these types of situations when they're just kind of learning their way?
That's always tricky because as a junior attorney, you want to impress, the partner, whoever it is that you're working for. You don't want to be the whistleblower. But sad but true, I have known attorneys who have been placed in that position, and it becomes a moral question, an ethical question,
Right.
because you will get in trouble, the partner will get in trouble. If you say something, it's likely that you can save yourself. But I know it's a very difficult decision for any junior attorney. So one thing I would probably say is a lot of the large firms and some medium firms do have ethics counsel on staff. If there is something that a partner or another associate is doing that I believe is that attorney, that junior attorney believe is not proper, it's unethical, I would seek out that person who's in the firm as the ethics counsel or general counsel and speak to that person. If I do not believe, or if that attorney, for whatever reason, believes that information will not be confidential and it may be shared with someone else, then it's incumbent on that junior attorney, sad but true, to seek counsel elsewhere. And I would advise that junior attorney to reach out consult with an ethics attorney about what their obligation may be. And if the attorney have performed those actions, they could really save their license. I know of a case where I've investigated that matter. And when I deposed the junior attorney who alleged that they were going along with the partner as to whether or not they sought counsel as to what their ethical obligation was, that attorney said no. Had they, it would have mitigated the sanction. That would have provided mitigation, that is. And the attorney ended up getting a year suspension, both in federal court and state court. Okay, and the partner also got suspended and was later disbarred.
So, Kaylin, I know that obviously in the past that you investigated these things, but now you're essentially on the other side that you're helping a lot of individuals through these types of crisis. First of all, no, we have your contact information here so they can contact you easily. But what are the steps that you do to help people through these problems?
I like to say, yes, I did. One of the things I am very thankful and really grateful that I have that experience. I come in and I'm looking at my client's matter and I put on that prosecutor's hat in the first instance. I am, looking at it from the perspective of the prosecutor, the person who's investigating it. I want to see what they are looking at before I respond. So I like to say that I am thorough in my investigation and preparation, because although I'm no longer prosecuting these matter or investigating it, that's one of the first things that I do when a client retains me before I plan my defense as to what it is that I need to do. And there is no substitute for being thorough. There's no substitute for going above and beyond. And when a client retains me, if they're looking for, okay, I just want a shadow attorney to send in a response so that it's not my name on the document and I can have an attorney at the front, I am not the right attorney. There are attorneys who will do that, and it's great, and it costs a lot less, but I don't want to come in there. If I'm going to sign my name to it, it must be done properly. And I think that has served me well in the last 7 years I've been defending. And until proven otherwise, I'm going to continue to address and go attack the problem in that manner.
Fantastic. So, Kaylin, when should people contact you? When is the thing that should pick up the phone or send you an email? Say, I need to talk to Kaylin today.
At the outset, right? Before you even definitely when you have a complaint, right? Don't respond to the committee without first speaking to counsel. You're too close to the matter. You're emotionally involved. You cannot objectively evaluate the matter. And even if you think you can, always remember that the complaint or what is alleged that starts the investigation, the committee is not confined to the four corners of that complaint. They don't have to just stay and investigate that. They can go beyond the four corners of the complaint. And so you might be like, oh, this was simply XYZ, but in their investigation, they may uncover something else. And there is no limitation if they know that there's some unethical conduct that says you can't investigate it. So closing that can of worm real soon is very important. You get a complaint, you call someone. If you think there's an issue, if you think you're at a point where you're having some disagreement with what you may believe is a client that could make a complaint against you, even if you know that you're correct, you don't have to hire the person, but it might be beneficial to at least consult, just ask for a consultation, right? Sometimes you just need someone who has that heightened awareness when it comes to these matters to just listen and give you a different perspective.
Exactly.
And that could guide you. And, sometimes foreclose a complaint because it might change the direction that you're going in currently.
Well, fantastic. Thank you for coming on and give us all these great tips. And I hope to have you back again soon.
Well, thank you so much. It's been a pleasure and look forward to being back on if necessary.